that basis, objecting to the writ of garnishment would have to be found invalid in this situation, because I don't have anything submitted showing that that this was discharged in bankruptcy. Moreover, counsel, as an officer of the court, has indicated that he talked with the law firm that handled the bankruptcy, and that they conceded that this matter was not included in the bankruptcy discharge. Moreover,
Okay.
now I'm talking now. Moreover, the contract in this matter for the purchase of the vehicle commenced after the bankruptcy was over with. So this is not included in the bankruptcy.
Okay.
The other issue raised by Ms. Buchanan is that she hasn't received notice of this lawsuit pending against her. That she was not aware of this and did not receive notice at her address, etc. To the extent that those things may be true, she would have to file a different type of case. This is what's called post-judgment versus pre-judgment. And if there is something that you believe occurred wherein this case, this judgment should not have been entered against you, there are certain actions that you can take, certain petitions that you can file to address that. But when it's post-judgment, you can only deal with the issue that's at hand. And that is, since this is a garnishment, the only issue before this court is whether or not the garnishment can issue. And the issue there is whether or not there is a judgment. Is there a judgment in place? And the fact of the matter is that there is a judgment in place. That judgment was entered back in 2017. And when that judgment was entered, the amount of the judgment was in excess of $17,000. So there is a valid judgment, and the plaintiff can engage in actions to try to collect on that judgment.
I have one more question. I understood everything.
Go ahead. If you got a question, ma'am, give me a question before I go further.
Okay. The question to you, Your Honor, is because I wasn't aware of this until just recently, is there any way that I can lower the payment for this situation? I don't have a problem if that is the case. Like I stated, I looked at only thing I have did at this point was look at the credit report, which it states it was. But if you're stating if it wasn't discharged, I understand. But I can't afford $300 out of each check, Your Honor.
Yes, ma'am, I understand. All right, so what you're doing, what you're asking, ma'am, is you're asking the court to allow you to make partial payments under a voluntary and to suspend the garnishment. Is that what you're asking, ma'am?
Yes, I'm at least the most that I figured I would be able to pay is maybe $120 installment payment, sir.
Well,
without being a big effort. Go ahead.
The garnishment has you at $600 a month approximately. And how much are you asking to pay a month?
At least 150 if you don't mind, sir, because otherwise I'm gonna end up getting evicted from my residence.
All right, counsel.
Your Honor, the installment payment motion is not before the court. If she wants to call, if she can write this down. Call J.
Let me stop you for a moment. She's made an oral motion before the court for installment payments, and the court is entertaining her oral motion at this time, counsel.
Okay, yes, Your Honor. How much she's paying $600 a month right now?
I can't afford it. I can't afford it.
Your Honor, I don't have full authority, but this is a pretty good client of ours. I think I can say that we could at least cut it at least in half, or maybe to 200 a month. 200, I think, that cuts it down 2/3.
Okay, I will accept that, Your Honor, if possible. Yes, sir.
I think it's very fair, Your Honor. 200 is more than fair.
Given the amount of the garnishments and given the amount of the judgment, the $200 amount is a decent monthly payment. I think that's a reasonable amount. I'll set the payment at $200 per month, and I'll suspend the garnishment in light of the $200 per month payment. So the garnishment would remain suspended as long as you make the $200 payment. If you miss the payment, then they can reinstate it. They don't have to start all over. They can just reinstate it because of.
Now, Your Honor, we are due a payment under the last 2 weeks. So the next, let's take the next check. We'll keep, if you don't mind. I'm not refunding, and we'll start February 1st with 200.
So here's what's going to occur. I will allow the next payment to go through on the garnishment, but I will stop the garnishment after that, and the commencement of your first payment. The commencement of your first payment is going to be February the 18th. So you'll get the next payment, but then your start of your voluntary payments will be February the 18th.
That's
So
fine, Your Honor. That's
yeah,
perfect.
you'll have a gap in between there. After this last garnishment, you'll have a gap. You won't have to make a payment until February the 18th voluntarily. And there won't be any garnishments in between this last garnishment and that date. You understand that?
I understand. So who do I send that to, Your Honor?
You would send it to Exchange Financial, but you would send it to Mr. Richard's office. And that information is on your the forms that you
information. Yes, sir. I do see that.
And
so what?
Wait, Angela, on the bottom of your check. I know the judge is busy.
Let me stop you, counsel, for just a moment. So that's going to be my order regarding this. I'm going to put the two of you in a breakout room to deal with the logistics.
Thank you very much.
But this will help you deal with the logistics so that everything goes smoothly, and then you'll get the appropriate orders from me. All right.
Thank you.
So, Miss, ma'am, there's your notification.
Okay.
And counsel, here comes your notification. All right. I wish the two of you well.
Thank you very much.
All right. Thank you, Your Honor.
Thank you. Just one moment.
You gotta be up here. Girl. What about up under it? Look up under it. Good. Oh, yeah. Okay.
All right, this is case number 19-17-5898. This is Gateway Financial Solutions versus Angelique Reed. The matter is before the court on the filing of objections to a writ of garnishment. Your appearance for Gateway.
Good morning, Your Honor. Zachary Schisler, P number 82247, appearing on behalf of the plaintiff.
Thank you, Mr. Chisler. Good morning to you, sir. Thank you for your patience in this regard. Do I have Ms. Reed on this Zoom? Ms. Reed, say something if you're there, ma'am.
Good morning, Your Honor. I'm here.
All right. Good morning to you, Ms. Reed. And that's Angelique, correct?
Angelique Reed, yes, sir.
Gotcha, Ms. Reed. All right, Ms. Reed, you filed objections to a writ of garnishment that was issued based upon a judgment in this matter. That judgment has a balance, it looks like, in excess of $9,000. It was entered on the 9th of December 2019 for $9,155.53. And when you objected, this is regarding state income tax return. You objected saying you were not served and COVID-19 came and you lost your job. That's the basis of your objection. Is that correct, ma'am?
Well, the basis of my objection is I never got served, for one thing. And then, like I said, I had, before the COVID and lost my job, I had been making arrangements with them. But then in the process of the COVID coming out, I lost my job. I was trying to get unemployment. The unemployment didn't kick in. And then the COVID kicked in, the pandemic that shut down the world. So I'm not denying that I don't owe them. I know I owe them. But again, they didn't contact me. I didn't contact them because I was trying to get my unemployment and my stuff together. And then in the mix of all of that, I wasn't even getting my mail on a regular basis because of the pandemic.
All right.
And I still don't get mail on a regular as today because they say they short staffed. So I want to make arrangements. I know at the time before I lost my job, I couldn't have owed them no more than $10,000. I didn't paid at least $4,000 or $5,000 into that before they tried to serve me. All those interest fees and stuff on there, I don't feel that I should owe because they didn't notify me. They say they notified me, but I didn't get anything from them until I got this letter saying that they were trying to take my state income taxes.
All right.
I'm not disputing it, but I don't feel that I owe that much, all those fees and all those late fees, because they never notified me.
All right, thank you, ma'am. So, Mr. Schisler, well, let me say a couple of things here. One is that the issue of the amount of the judgment and whether or not there was proper service and notification, I can't even address those issues because this is post-judgment. If you wanted to deal with those underlying issues, you would have to file something separately to address just that. What you did file is you filed objections to the garnishment, and you also filed a petition for partial payments in this matter. Let me ask you, this is regarding your state income tax return. Is that correct, ma'am?
Yes, that's what the document I got stated.
Right.
Then I also,
Let me stop you. So how much money are you expecting as your state income tax return? Do you have any idea how much you might be getting back there?
well, right now, you know, I'm not in the same tax bracket as I was then. I don't have no dependents now because my son is grown. So last year I broke even. I didn't owe them and they didn't owe me.
That's what
So
I'm getting.
I don't know.
You don't
I
know.
didn't get any money back. So I don't know what the situation gonna be this year. Again, I don't have no dependents and I haven't been working that long. I just started a new job as a security guard a few months ago.
All right, ma'am. All right, Mr. Chisler?
Yeah, Your Honor, as far as the income tax garnishment, it sounds like there may not be any money there when it comes, but I don't think she's raised a valid objection. She also filed a motion for installment payments. We're not objecting to that. So that's, she's addressed that she had a previous payment arrangement, that she was looking for another one. She was asking for $100 biweekly. We have no objection to that. But as far as the state income tax garnishment, we would ask that those objections be denied, or that they be found invalid. Sorry.
Yeah, first of all, ma'am, Ms. Reed, regarding the state income tax thing, there's probably not a valid objection there. If you get some money, if you had some money coming back, that would be applied to the judgment to help reduce the amount that you owe. So whatever that amount is, that would be applied. If you don't get anything, then that means that they can't get anything. But if you, let's say you had $100 coming back, that would go towards paying on the judgment. So I don't see a valid reason for the objection there. You file a petition for partial payments. That's a separate thing. Now, are you asking to make $200 payments a month, $100 every 2 weeks? Is that what you're asking?
Well, now, since my hours then been cut, with the pandemic going on, so now I'm asking if I can pay $100 a month.
Well,
Because I do have, my rent, lights and gas and other, bills that I have, but I'm not disputing my bill with them. And I'm also confused on the amount that I owe left on the car. Is it $9,000 or is it $5,000 or is it $6,000?
So, counsel, do you have a balance?
I do. So as of 12/30/2021, it was $6,673.40.
All right. So,
And that's what I arranged when I lost my job. I do know that I had still owed like a little, maybe 5,000, give or take. But now with all these fees and late fees, they didn't even notify me. My phone number hasn't changed. No one's called me. I don't feel like I should have to pay all these late fees.
well, I don't know how much of that is late fees or anything along those lines, ma'am, but if you want to file something with the court in that regard, then I'll take a look at whatever you file and consider those kind of things. It doesn't seem that the numbers are that far apart. It also appears that this judgment has been in place for 2 years. If it's been in place for 2 years, that's going to result in some accrual of interest on the judgment as well. So here's what I'm going to do. In light of your petition for partial payments, I will set the payment. I will set the payment at $150 per month. And I'll have that payment commence on January 28th, 2022. And as long as you make those payments, then no wage garnishment will issue regarding this matter.
Okay, I can afford $150 a month, sir, but I get paid every 2 weeks. I don't get a paycheck on the 28th. I just got paid, I think, on the 1st. So my next paycheck, I think, is around the 14th.
All right, so that's what I'm getting at now. The 28th gives you a longer period of time to pay.
Oh, okay. I got it. I just didn't know if that was the day that I had to pay. Now, one more other question. Where would I be sending this payment to every month?
All right, and I'm gonna give you the opportunity to talk to Mr. Chisler so that you guys can work out exactly where the payment should be sent. And again, as long as you make that payment by that last Friday of January, you can make it earlier, but it's got to be by of January. Then every month, the payment is set for the last Friday of every month thereafter. So as long as you make it before the last Friday, on or before the last Friday, you're all set. You understand?
As long as I make it by the 28th, I'm good.
That's correct. Yep.
Thank you, sir.
All right, you'll get orders from me in the mail on both of the garnishment as well as on the installment order. And I'm going to set it up for you to talk with Mr. Chisler just to go over the logistics of where you make your payments so that this can be all set up. All right, so I'm going to send you a notification to go to breakout room number 3. and just click on your device and it'll take you to that particular spot. And the attorney.
So am I hitting the join? I don't mean to interrupt you, but it came on my phone. Am I hitting the join button now for the break room, sir?
Yes, ma'am. Yes.
Happy New Year, Your Honor. Thank you so much.
Likewise to you. Good day to you, ma'am.
Have a wonderful day. Bye.
Okay.
The court calls now 21-47204. This is Second Round Subs LLC versus L'Oreal Johnson. The matter is before the court on objection, filing of objections to a writ of garnishment regarding the Department of Treasury of the state of Michigan. This relates to a judgment that was entered on or about the 16th of September 2020 for $1,264.83. For the plaintiff in this matter, your appearance, please.
Good morning, Your Honor. Dawn Blair on behalf of the plaintiff, second round, P62601.
All right, and good morning to you, Ms. Blair, while we still have some morning left, and thank you for your patience in this regard.
No problem.
Now for Ms. Johnson, L'Oreal Johnson, say something if you would be.
Yes, L'Oreal Johnson.
Thank you, Ms. Johnson, and good morning to you, and thank you for your patience as well, ma'am. I am looking at your objections to the writ of garnishment regarding the state treasury. It says the maximum amount of law is already being withheld by another court. Tell me what you're talking about there.
I had another garnishment that was I forgot what the garnishment for, but that one has been reduced. I make payment arrangements on that, so they're no longer garnishing me, but I just have to pay them a certain amount per month.
Okay, yeah, you have an arrangement on that. So
Yeah. On that.
What does that have? This is a different type of garnishment, you know.
Yeah. Different type of garnishment.
Yeah, this is a garnishment of a potential income tax return. So how would that relate to what you were just telling me?
I thought it was a garnishment for my checks, so that's why I issued a stop. I usually don't really get that much back.
Okay. Do you work? Let me stop.
Yes.
Do you work for the state?
No, I don't.
Oh, okay. So it would not be your wage garnish. It's not a wage garnishment. It's an attempt to garnish income tax return. If you get any money back, it will apply to the judgment. If you don't get anything back, then you know how that works. Nothing.
Your Honor,
Your Honor,
if I could just clarify though, there are no payment arrangements.
Ms. Blair, 1 second, ma'am. You understand what I was saying to you, Ms. Johnson?
Yes.
Ms. Blair, I'm sorry, Counsel.
No, I just wanted to clarify for Ms. Johnson also, there are no payment arrangements on this specific case. So while I agree that this is a tax garnishment and the tax garnishment would still be valid, technically we could still do a wage garnishment too, because you don't have payment arrangements set up on this specific case.
Right, and that's a thing that's not before me right now. But if there is a garnishment filed against your employer, they could attempt to garnish wages, notwithstanding this income tax type garnishment. You don't have that issue now. And a part of the reason that comes up is that one of the ways that you protect from that wage garnishment or potential for wage garnishment is by what you did with whatever that other case is, and that is set up some type of partial payment arrangement. So you might want to consider trying to do something like that. But then that's, you know, that's something just to think about so that you don't deal with the wage garnishment type situation. As it relates to the thing that's before me, and that's the objection to the state income tax return type situation, I don't see a valid objection to that. The objection you raised was the maximum permitted by law, and that's not, the law would permit the intercept, and there's nothing that would kind of stand in the way of that. So I'm going to find that the objections on that issue are invalid. Now, this has nothing to do with wages or potential wage garnishment. This don't have anything to do with that. It just means that if you get a state income tax refund, they would be able to intercept that and apply it towards the amount that you owe as a judgment in this matter.
I'm fine. I'm fine with that. Take care of it.
That does not prevent a wage garnishment. If they file something that your employer, they find out who your employer filed something, they could intercept. That would be a wage garnishment. That's a different type of garnishment. Now, that's not before me today, but you might want to consider filing a petition to make partial payments to try and prevent that. Okay. All right. So I'm going to sign this order consistent with what I previously said. I do wish you well. Ms. Johnson, thank you, counsel. Good day to both sides.
Thank you.
Thank you, Your Honor.
The court is looking to 08143-148. This is Daimler versus Kimberly Simpson. I did get the notification of counsel's presence on this matter. The matter is before the court on objections to a writ of garnishment. This seems to relate to the Michigan Department of Treasury. All right, and your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Deborah Winslow, P63179, on behalf of the plaintiff.
Thank you, Ms. Winslow, and good morning to you, ma'am. Again, thank you for your patience in this regard. I'm looking now for also Ms. Simpson, Kimberly Simpson, if you're on this.
Yes, Your Honor.
All right. Good morning to you, Ms. Simpson.
Good morning, Your Honor.
Your patience in this regard as well, ma'am. I know you've been waiting a bit. It looks like this is an objection that relates to a judgment that was entered by default back in 2009 for some $7,025.76. And you stated as objecting to this matter, well, you didn't check one of the boxes. You object to the written statement I received from a creditor because the balance of the judgment is wrong. Go ahead and talk to me about that, ma'am.
Okay, Your Honor, thank you. Well, I have a couple concerns, but the thing about the balance, unfortunately, Your Honor, at that particular time when I fell behind in my car notes back in 07, well, actually, yeah, 07, it was due to a health concern because I was hospitalized 12 times in a year. And eventually, they did surgery, so I fell behind in my payments. November of 07. I made a payment arrangement because I had just, I got back to work. So I made arrangement because I was 3 months behind as of November. I made arrangement to come in on that Friday to make 2 payments to bring it up. They repossessed my car Thanksgiving Day, that Thursday, before I can go in and make a payment after agreeing, verbal agreement over the phone. So in the process of that, I lost my car, I lost my health, I lost my home, and I lost my job due to my health issues, all in that whole year. At that time when they repossessed my truck, I was staying with my sister because I lost my house due to the owner losing the property and not telling me. And so my only objection is they have me right now is owing them $8,873. And at that particular time, I was leasing the Jeep the 05 Jeep, I was leasing it and I think my payments was $336 a month. And in November of 07, I was 3 months behind. My lease would have been up February of 08. And I just agreed with the amount because, and I know they tacked on court fees and everything, but at that time I was 3 months behind and only had 3 more months to go when they repossessed the truck. And right now, you know, I'm on disability and I do little side jobs like the taxes. Well, the reason I had got taxes back this time because I do have, it's not Avon, but it's a Cincy. I do that on the side to help make ends meet because my disability don't pay all my bills, even with me being on Section 8. So I'm just trying to, work out something to where with what they have already taken from me, the fee, the amount is just not adding up. And then I tried to do a car search because the car that they took from me was in excellent condition, nowhere near the mileage and everything, to where when they took the car, there's no way they didn't resell that car. Even if it's used, the car was perfect condition. And so I went to the Secretary of State where I got an appointment because I've been sick and then I had family emergency. My son had a heart attack before Christmas. So I had to go to him. But I did go in, but they said they can't even find, because I still had the VIN number and everything. They can't even find the car as being registered since it was repossessed from me. They said unless it was sold out of state. So they gave me the forms to file an individual record request to do a complete title history. And the only reason I'm trying to do that is because I feel if they sold this car, and I don't know if they did or they didn't, but it was a dealership. If they sold this car, I'm sure they got top dollar for the car, way more than $8,000 for the car. But they trying to get money out of me also. And it's like, to me, that's like double dipping. You didn't already took a car from me 3 months before my lease was up. And yes, I was 3 months behind, even without arrangement for me to come in. But on top of it, you want me to still give you money for a car that in my heart, and knowing the condition of the car, I know you sold the car. And so I know they told me it would cost me $12. Like I told them $12 is nothing. I just need to know what is the status with this car? Because they were saying if I could find out the car had been registered after it was repossessed,
Okay,
they may be able to give me some information on the car. But because
I gotta stop you. Yeah, I got your point. You gotta go on that the third or fourth time.
I'm sorry, Your Honor.
And that's no problem. I heard you out on it. I mean, the biggest challenge that you have with this is that in this particular hearing on the issues that's raised in this hearing, none of those things are relevant to this hearing because this is post-judgment. There's a judgment already entered against you. Now, you can always, the law allows you to always go and file a motion to try and set aside something that has occurred in the past. But the challenge that you have, the enormous challenge that you have is that some of the things that you're raising now, if you want to raise those issues, you would have needed to raise those issues back in 2007 and 2009 or even 2010 or 11 or 12. So you're basically right now, I mean, you're looking at 15, if I'm counting, 15 years ago is when this judgment was entered, and then it was renewed 10 years after its initial entry. So you're talking about a long, long time ago. And then the other issue is that, sometimes there is a windfall, as it seems, that occurs by virtue of what the law allows. For example, if your car is repossessed, even if you're near the end of the lease, if that vehicle is repossessed, the company repossessing it, they have the right to put it into the marketplace by way of an auction. And at an auction, it goes to the highest bidder. And typically, that highest bidder is bidding way beneath what the top dollar amount is. And the deficiency between what the contract calls for and what was taken at the auction, that deficiency becomes the amount that you become responsible for. That's just generally the way that works, and that can be oftentimes a rather tough pill to swallow. But the Uniform Commercial Code and other laws allow for for products that are in the stream of commerce to be sold off in a certain way if there's a default under the contract. And sometimes the paper, what's owed on paper is a whole lot more than what even the vehicle may call for. But the law allows for the plaintiff to collect based upon the agreement that the parties had. That's the part of what's going on. Here today, the only issue that's really before me today is whether or not some money is owed and whether or not there is a judgment based upon some money being owed. And if that's the case, then the plaintiff has the right under law to collect on the amount that is owed to them. And so your challenge here becomes today, how much money are you expecting from your income tax return? And whether or not that amount is going to be way over the amount of money that you may owe. So the judgment in this matter, as I mentioned to you, is somewhere north of, I think, $7,000. Are you going to be getting $7,000 back from the state of Michigan?
No, Your Honor.
How much do you think you might get? If you get a tax return, how much do you think it might be?
Ooh, well, I know it's not gonna be nowhere near that. And the only reason it might be maybe close to 2,000 is because of the unemployment that I received towards the beginning of last year. And that's the only thing that would increase, what I may get back. Because normally I don't really get anything back, other than home heating credit, and because I don't work. And the only reason I've been doing self-employment, which is like Cincy, which is like Avon, if I make commission that month, then I get a little, I make 25% off of whatever I sell. So that's how I fell into the bracket of self-employment. And that's the only benefit I would have from getting unemployment, that my taxes would be a little more.
All right, thank you. Let me stop. Ms. Winslow.
Yes, Your Honor. As Your Honor indicated, the judgment was entered in this matter in January 27th, 2009. Our position is that the defendant has not raised a valid objection, and we would request that the garnishment objection be denied and that our garnishment stand.
Yeah, I've listened to the statements offered. I reviewed the file in this matter. And what it comes down to is a simple proposition. That is that there's not really a valid objection to the garnishment. Some of the things that are raised by Ms. Simpson might lead her to want to file some type of motion to ask that the judgment amount be reduced or something along those lines and show a valid reason for that. But at least as it relates to the judgment is validly entered. There is money that is yet owed on the judgment, and the objections have strike that the garnishment have been filed on that basis. For that reason, I will find the valid. The objections are not valid in this matter, and therefore any funds that might be withheld by the state would be released to the plaintiff to go towards satisfaction or payment on the judgment that is outstanding in this matter. And I'll sign an order consistent with that. That is my ruling and determination at this time. I do wish you well. Thank you, both sides, and all the best to you. You come up here as Ms. Simpson. You also have Ms. Crenshaw. Ms. Simpson, all the best to you. I wish you well in your journey.
Thank you, Your Honor.
Thank you, Your Honor. And the court will send us an order.
That is correct, Madam Counsel.
Thank you. Have a nice day.
Thank you. And likewise to you.
Thanks.
All right, the court now calls case number 21-149-104. This is Midland Credit Management versus Danita Etheridge. The matter is before the court on the filing of objections to a writ of garnishment. This is regarding the Department of Treasury, State of Michigan. And I should indicate that there was the judgment was entered in this case by default on the 9th of June, 2021. The judgment is $742.43. For the plaintiff in this matter, your appearance, please.
Good morning, Your Honor, Navjot Francis, P72322, on behalf of Plaintiff's Attorney of Record.
Thank you, Ms. Francis, and good morning still for the next few moments to you again. Thank you for your patience. I'm looking now for Ms. Danita Etheridge. If you're on the Zoom, please say something at this time, ma'am.
Yes, I am.
All right, and good morning to you. Thank you for your patience. You probably heard a whole bunch of cases already, ma'am.
Yes.
I see that you, of course, you objected to this garnishment that relate to the state income tax return, but you didn't provide any basis for your objection. You said the writ is not properly issued, otherwise invalid. Then you put not applicable there. So what's going on? Tell me what you want to tell me.
Okay. Well, the reason why the paper is like that, because when I asked the lady for help, she couldn't give me any legal advice. So I had to go with the flow. So basically, when they had sent the judgment in June, they stated, I didn't receive it until afterward. And then when it was time to notify the courts was closed. But I'm not just, disputing that I owed the money, because you had a credit card from them for $300. Okay. So by me not keeping the timely payments and everything, it went up. Okay. But right now, I don't have the cash. And like when I called and talked to a gentleman about it, when I tried to make arrangements, he was so rude. And I was like, okay, it's not necessary. Okay. It's not like I'm not trying to get over on paying y'all the $700. Okay. If I don't have it, I don't have it. I don't work. I have 2 minor kids that's still in school, and I have bills, and I don't get bridge card and all that stuff. I live off of monthly income, of SSD. So they said they're going to take my taxes. How can they take anything? I don't even file taxes because I don't have a job.
So
Something else. I'm serious. I tried.
I'm not laughing at your predicament. I'm laughing at your matter. Your matter is humorous.
You know what? I can't help it. I love life.
I know. I'm one of 9, and so of 9 siblings, somebody or a few people in the family are just humorous. They can't help it.
We're just honest. We're just honest people. Yeah, we're just honest. So we can be humorous.
Absolutely. Well, the question. I mean, you say you don't even file income tax return, correct?
No.
You don't file anything with the state?
No.
So this whole thing is moot then. The only way that they would be able to collect anything from the state income tax is if you file the state income tax. Or if you won the lottery, they could get you there though.
Well, to my understanding, they said that they can go after my SSD because it's considered an income. The SSD, because it's considered an income. It's not like SSI.
Wow.
So that's the reason why I called, because I'm like, that's the money that I live off of, So if I get $800 out for the SSD, I still have my life and kids to take care of, plus groceries, because they eat you out of house and home. And it's like, I'm dogging if I do, I'm dogging if I don't. But I'm not trying to go to the mailbox and little Johnny can't read and I'm screwed because I'm a dang on money gone because, I messed up with a credit card. But I will say this. If they will work with me, I'm willing to give them $25 a month till I get them paid off.
All right. Well, let's just deal with this garnishment. Ms. Francis, it doesn't seem like, it seems like a mute question here because she would not have a return coming from the state of Michigan. So there's nothing there.
Judge, we don't know if she's gonna file her taxes or not, so it isn't moot, but it should be, her objection should be denied. I'm not sure if she misunderstood what they said about her social security, but they would not have, I don't believe anyone would have said that. If however she did file taxes.
You weren't there. You wasn't there. So
Exactly. But
you wasn't there, so you can't say what someone else said because you was not there.
Okay.
If you could. You went from humor to fussing now. Of course she wasn't there. And if somebody said something to you to that effect, the bottom line is that they're wrong. I mean, if you're receiving a benefit, that's a federal benefit that you're receiving, correct, ma'am?
Yes, ma'am. Yes, sir.
That's not subject to garnishment. Nobody's gonna be able to garnish that. They're not. Now, if you had some reason to file, and I'll come back to you, Ms. Francis, I'm sorry. If you had some reason to file a state income tax return, then they would have the right to intercept that. Because you don't really have there's not any valid objection to that. But if you don't file anything, then there's nothing that they can collect from a state income tax return type situation. Again, this could also apply that if you played the lottery and you had some state winnings, they could intercept state winnings if you won, if you won, what is it now, 550 million or something? I heard it's 600 million. And I know that if you get 600 million, you won't have a problem with them taking that little 700.
No, they can have it.
Ms. Francis, you were saying something. I'm sorry.
I'm sorry, Judge. I didn't mean to interrupt you. I was trying to say to Ms. Etheridge that the same thing, Judge, that I don't know what they said, but I do not believe they would have said that. And it is not true. But what I believe they may have been saying is that if she did file taxes, we would still be entitled to it no matter what her income is.
Mm-hmm.
Right. Yeah.
I respect that.
And that's the thing, if there's a way that if you file taxes and you have a state tax return coming, then there's a way that can be intercepted even if you don't have any money otherwise. That's the challenge. So I'm finding the objections invalid. If there's an income tax return, then the plaintiff would have the right to try and collect that to apply to this outstanding balance of the debt. You also have the right, Ms. Etheridge, if you wish to file a petition or to speak with Ms. Francis and come up with an agreement for maybe $25 a month to pay on this, if that's what you wanted to do. Or it's up to you as to whether or not you want to take action in that way, ma'am.
Judge, we would be agreeable to $25 a month. Ms.
Etheridge, you heard the statement there?
Yes, I appreciate that.
So do you want me to sign an order for you to pay $25 a month? Or you just gonna start sending $25? What do you want to do, ma'am?
I can send it to her monthly or to Midland, or I can send it to Midland if that's what they want, or she can send me a payment sheet and I can just make sure it's in the mail. I don't know, whatever they want to do. I'm willing to work with them.
All right, very well. So I'm going to, she's going to send something out to you for the voluntary payment.
That's fine.
And set up a way for that to get paid.
That is fine. I appreciate it.
I wish you well, Ms. Etheridge. Good day to you. Thank you.
Thank you so much. Okay.
Thank you, Judge. Happy New Year.
Happy New Year to you as well.
We did our Della Clark already.
Which is
You did the first one already, Ms. Clark, our Della Clark. It's 109. 109.
I don't remember doing that.
I think you don't have a file, but you just got a jacket. And 109 Ardella Cross.
Adela Council,
Yeah, right here, Ardella Clark.
5671 Complaint.
Uh-huh.
That was council.
Yeah, I did that.
Oh, you did that one? Oh, okay.
That's, her last name is Council.
Oh, council.
That's how it reads out on the objection.
What about Rainer Samuel?
I did Rainer.
You did that one?
Some stuff I have to come back to.
Yeah, because I think you called the name.
275 didn't answer.
Yeah,
You called
275
him
didn't answer. And then, what about Falls Lake National?
Yes.
Because I was trying to make sure.
I know, I'm gonna go.
Oh, okay. I'm like.
You want one right at the other. I'm sitting there trying to figure out.
I know a couple of them didn't answer.
Okay, so on this council one, I did not, she wanted to, reduce.
Okay, reduce that.
And that was denied.
Okay, all right.
And so, and I said we will send her a notice. For review.
Okay.
6 months. Okay. So only thing you do on that is send out a notice for 6 months. Okay, now, on auto insurance, the objections to the writ of garnishment were denied. I believe that. Oh, yeah. And I agreed to allow her to make partial payments.
Who was that for me too?
This was the subject 798.
Okay, yeah.
Terrell Washington. And I needed a partial payment for that. Do you remember what I did on that with Ms. Washington? I think I said we were a partial payment order.
That was the young lady you said, I think you said Randy, and then you said, is that the one where you told her that she was objection to ground for, that was for her income tax, is that the lady for the income tax?
Right.
Oh, okay, all right. So it says, I just wrote down here objection to ground, because you denied it, but then you said you would give her the, her objection to ground was denied because it was income tax. I thought that was it. Let me see what I put in here.
So I have that order.
Okay.
And that's what I did on that, as to the state of Michigan home. But then I set aside her garnishment on her income tax.
Oh, yeah, because I think she wasn't working, so it says defended, oh, yeah, all funds for her to be released, so I already did that, yeah. You want her to pay $100 a month.
$100 a month, is that what it was?
Mhm.
Okay, all right. And do you know what commencement date I put on that?
It says defendant shall pay $100 a month. Oh, they were already charging her, you amended it, right?
Right.
Yeah, you amended it, you said just set forth because they've already been paying. So you said for her November payment that she would continue, they will continue to keep paying. So she just keeps going, you know, to just continue.
So I had to amend it to include on here to stop the garnishment. That's
Yes,
what it was.
you stopped the
Okay.
garnishment.
And that garnishment date, what was the garnishment?
Her file 798. I think there was in here, she's like 798.
I don't want to confuse this with.
No, I know that because I wrote it in the system when you did it, so.
Hello, excuse me.
Yes.
Oh,
Who I have out there?
Yeah, it looked like you have a iPhone person and Miss Blair is still there for some reason.
Okay. All right. Ms. Blair, which matter are you?
It is for Jefferson Capital versus Latoya Smith, case number ending in 188.
And I haven't called that one. That's right. I had it saved. This is case number 2016. 188. That's Jefferson Capital Systems LLC versus Latoya Smith. The matter is before the court. Looks like on objections to a writ of garnishment regarding Chrysler Group. And also, all right, well, actually, that looks like the only objection, the only document that I'm looking at on that side. All right, your appearance, Madam Counsel.
Good afternoon, Your Honor. Dawn Blair on behalf of the plaintiff Jefferson Capital, P62601.
Okay, thank you, Counsel, and good afternoon to you. Ms. Smith, do I have Ms. Smith there?
Yes, Your Honor, I'm here.
All right, for some reason you're not appearing on my screen, but I do hear you loud and clear. All right, you did file the objections to the writ of garnishment, and basically, you didn't check off any of the boxes, and then on the final line there, you put fraud. This case comes as a result of a judgment that was entered on the 24th of September for $1,698. So what do you, tell me what you're talking about in regard to this matter? Ms. Smith?
Yes, Your Honor.
Oh, yeah, did you hear what I said? I told you when the judgment was entered, you put on here fraud, and that's all I have to work with. Let me ask you one question before you tell me about that. You work for Chrysler Group, is that correct?
Okay.
All right, so this is a garnishment against your wages,
Yes.
true? Okay, so tell me why you believe that the garnishment should not be effective, ma'am.
I'm so sorry. It's like now the connection is terrible when it's on me, but the whole thing.
Let me ask you, let me see if you can hear my question, and then let me know if you hear my question. And I know sometimes that sound gets kind of crazy. Are you dealing with an earpiece?
Yes.
Yeah, you might want to. I'm wondering if you take the earpiece out, if that might be better, but. Are you? Let's see.
1 second.
All right, is that better?
No, it's not.
Okay, so go ahead. Go ahead and tell me about your objections. Go ahead and discuss that with.
I think she's on mute now, Your Honor.
Okay.
Okay.
Go ahead and tell me about your objections, Ms. Smith.
I apologize. So the objection is because I did not have any account with DTE, because that's where this is occurring from. It's from DTE. I never had DTE in my name. I actually filed for identity theft back in 2019. And that was when I was aware of the balance with DTE, which was at the time about $1,600. So I since then had that collection removed off my credit because it was fraud. And then I proceeded to have DTE put into my name, moving forward, because that was like the whole thing. Like, I didn't even know that I had owed them until I needed to have service turned on. So I paid them a deposit of $650 to even have service turned on at my residence where I am right now. And I've been. So, hello?
Yeah, I'm still here. I can hear
Hello?
you. Can you hear me okay?
So, yes, so that was the main thing, sir, that I do not owe this whatsoever. Never had DTE in my name. And this is my first time ever doing service with them as of right now in my new home.
So why didn't you respond to the complaint when they filed a complaint against you that ultimately they got a judgment? Why did you answer the complaint?
Are you talking about back in March of 2020?
Yes, ma'am.
Yes. I did not do it, only because it was not on my credit. I had that removed in 2019. So when I got something in the mail regarding Chrysler, Jefferson Capital, I didn't know what that was until I looked into it, and it was DTE. Jefferson Capital basically paid DTE the debt that was owed, but it was never a debt that I created.
Right. But if you get something, if you get something saying that you're being sued, you have to answer that. And if you don't,
Right.
That's what this case is about. That's it.
Yeah.
You know.
And I'm noticing it now. It's just I didn't have the proper guidance to even understand. I've never been sued. I've never even been to court. I didn't know anything of what it was. And once I seen it, it still wasn't on my credit, because I went back into my credit report to look into DTE, and they didn't have anything on there. So I'm like, okay, they can't be saying I owe them anything because it's not on my report. So that definitely was on my end, but I obviously kicked into it once they started the garnishments, because this is not true. It's not something that I actually owe. So.
All right, Ms. Blair.
Your Honor, I would just point out, well, first of all, I'm acknowledging that she's claiming this is fraud, and I will send her a fraud affidavit for her to complete so that our client can review it. That said, her objection to garnishment should still be denied, because it is an invalid objection. There is a proper judgment against her, and she cannot, under the court rules, attack the underlying judgment via an objection to garnishment. The garnishment is valid, was issued validly on a valid judgment that was valid. And if there's some sort of fraud that's determined by our client, then anything that's occurred up till now would be addressed at that time.
Yeah, the challenge here is that the challenge here is that the law does not allow you to attack it the way that you're attacking it. You're dealing with the garnishment is a post-judgment issue, and you're raising pre-judgment issues. So there's a way for you to raise that, but the law doesn't allow you to raise the pre-judgment issues in this post-judgment matter. But the law does. It looks to see whether or not a judgment has been entered, number one, and then number two, if the judgment has been entered, whether there is an action to collect on that judgment. There has been a judgment entered. There's an action to collect on it. That's why the objections are not valid here. Now, there are a couple of things that you can do. One is plaintiff's counsel has pointed out that they're going to send you a fraud application so that you can fill out the appropriate paperwork, so that can be reviewed to see, so they can determine on their end whether or not they can validate the fraud situation. If that's the case, and this case comes to an end in that way. The second thing that you have the right to do is you have the right to file a motion or a petition before this court, asking the court to review this judgment based upon the issues that you raised. That could be in the nature of a motion to set aside the judgment, set aside the default. You could raise that. And when you bring that issue, you want to present two things. Number one, why you didn't respond when you should have. And then secondly, what your defense is. Why didn't I answer when I should have answered? Secondly, what's the defense that I raised? And of course, you pointed out here orally that your defense to this is that it's fraud. You have to put something like that in writing, and you have to explain why you didn't answer earlier, why you didn't answer when the paperwork was submitted to you. You have to put that in writing and file it as a petition before the court. And at the same time, the application that they're going to send to you, you have to fill out that application, because again, if they can validate that this was a fraud on their end, then that would bring an end to the case as well. Now, the question becomes, what happens in the interim? Well, this is a garnishment against your wages. How much money are they taking?
Yeah, they've been, I'm sorry.
Yeah, I mean, that's, so we got to deal with that part right now. How much are they taking per pay period?
There is on a 25% tile off my check. So it varies.
You know, I know that part. You know what I'm asking for? I'm asking for a raw dollar amount. How much they take per period?
Around $200 every week.
Okay, so about 800 a month.
Right, and that's what I'm saying. Like, it's almost paid off, and the thing is literally fraud. Like, I have DTE in my name right now that I'm currently paying still.
Let me stop you from talking about that because I told you how you have to go about that. If you
Okay, I know. It's still crazy because I would at least appreciate the garnishment to be stopped because it was never me from the beginning. I will fill out the affidavit for the fraud, but as of right now.
Let me stop you. Let me stop you. I'm trying to see if we can get you there. Right?
Okay. Okay.
You put yourself in a position, unknowingly, but you put yourself in a position where that could occur because you didn't answer that complaint early on, okay?
Right, I agree.
I believe you when you tell me that that this was a fraud situation, but you have to go through the steps in order to get to that. I believe that you are operating on some good information, and if we can discover that, that'll get to that particular conclusion. So what I'm prepared to do, Madam Counsel, is I'm prepared to set up the payment at $100 a month while this fraud investigation occurs. What happens, ma'am, is that would stop the garnishment, and also if it's established that this was fraud and the case is dismissed, you get all your money back. But right now, because there's a judgment against you, you have to still pay on this in a way until we get to that conclusion. If for some reason we're not able to get over that hump, then the money that you paid will be money that goes towards paying this off. If you get over that hump, the money that you paid will come back to you and have to be reimbursed. You understand?
Yes.
So anything at this point?
I'm not sure if you asked me if there was anything. I just want to clarify what you just said. You're going to issue an order for monthly payments to be made by Ms. Smith for $100.
So
effectively suspending the garnishment.
Right. The first thing that's going to happen is that the objections, the court would conclude that at this point, the objections are invalid and that therefore any funds withheld would be released to the plaintiff. But then I will stop the garnishment and allow for a monthly payment of $100 during the pendency of whatever action she's going to take to fill out the fraud application and or file a motion with the court. And then, of course, if it's found that it's fraud, the case is dismissed, and of course, the money would be refunded to her. In the interim, it would give her the relief from the garnishment in light of the issues that she's raised. I think that those issues I think that there were some investigation for sure.
Okay, and so if with the $100, then it's basically going to be an installment payment order. And if our client determines that there was not fraud involved, she would still continue with that installment payment order, correct?
Until it's paid off.
Okay.
But of course, if the fraud is established, then that means that any money paid would be refunded. If it's not established, then that means that she's just paying it off at $100 a month until the balance is.
Perfect. That makes sense. Thank you.
Okay.
And one question, Your Honor, is that going to, the next payment that's due, are they going to take that out of this check, or is there like a date that we can set up until that paperwork comes, like the end of this month, if that could work?
Yeah. I mean, you're not going to be able to avoid the garnishment this week. So what my order is going to do, my order is going to stop the garnishment after the 7th of January. So the 7th of January will be the last garnishment that they can make. After that, I'll set up your first partial payment of February. That first partial payment will be February the 4th.
Okay.
2/4/21, $100. The garnishment stops after the 7th of January.
And Your Honor, for clarification, I think just for Ms. Smith, that the $100 a month, your employer is not automatically going to withdraw that. That would be something that you're going to send on your own.
Okay. Okay. So do I talk to you separately to get the information for you to mail out the correct forms and everything?
I'm gonna go ahead and put you in the breakout room and you guys can go over that and you'll get the order you'll get the orders from me in writing, in regard to how all of that, what happened.
Okay. And after the breakout room, we can just leave. Is that correct, Your Honor?
Yes.
Okay.
Yes, you can break out. All right, there you go. All right, I wish you still be well.
Thank you.
Thank you, Your Honor. Have a great day.
Yeah.
Well,
Hey, Deborah.
hey, girl. I guess I could open up the window now. Isn't that special? Judge, did you think you were on landlord tenant?
Yeah, I kind of felt that way today.
Do we got somebody? I think we got somebody else on there, don't we?
No.
Don't say
Hey,
4 people. Okay.
I needed to get the young lady, in the breakup. I need to get her to chat me her email.
Oh, the lady in the breakout room?
Uh,
Or the one that already went in the breakout room?
Yeah, the one that just went in there.
Did she know to give you her email?
Says I can broadcast a message to her.
All right. Now it's say live.
Why is that even happening? Why is that even happening?
Well, I gotta see y'all tomorrow. Guess I'll catch y'all tomorrow.
Yeah, you'll see us tomorrow. We only have, it won't be as bad tomorrow, Deborah.
No, it wasn't bad. It was just shades of it wasn't
People, they was getting a little different on us.
yeah. It was like landlord tenant.
Yeah, that's what I was feeling, but we got past that, so
Yeah.
we all right now.
All right then, I'll see y'all tomorrow.
All right, Deborah.